You're listening to the Texas Appellate Law Podcast. I'm Todd Smith.
And I'm Jody Sanders.
Our guest today is Chris Schandevel. Chris is Senior Counsel at the Alliance Defending Freedom. Chris, welcome to the podcast.
Thanks, Todd. It's great to be here. Thanks for having me on.
Well, there may be some of our listeners and watchers who already know who you are because you've got a really strong LinkedIn presence and talk a lot about what you're doing there. But in case they haven't heard about you, tell us a little bit about yourself and how you came to be a lawyer.
Sure. So a little about myself and how I came to be a lawyer. You prefaced that by saying a little bit, but as you know, I'm an attorney, and you asked me how to tell my life story coming to law. I'll try to keep it to a Reader's Digest version by attorney standards, at least, for what that's worth.
We can do a red light, green light if it helps. I can put one on my phone.
Oh, sure. Yeah, no. As long as I get a yellow in between to know when to speed up, right? The practice of law is a time when it's okay to speed up when you see a yellow light, right? When you're standing at the lectern and doing an argument. So I graduated law school in 2012 from University of Virginia School of Law. I did an appellate clerkship on the Virginia Court of Appeals for a year and a half after that. From there, I went to the Office of the Attorney General of Virginia, took a job in the criminal appeals section. I spent 5 years litigating criminal appeals in that office before coming to Alliance Defending Freedom, where I am now. I joined ADF's appellate team. I think it's coming up on 8 years now that I've been on this team. ADF had always kind of been the dream of mine. We can get into that. More of that if you'd like, and kind of tell that story. But ADF had been the dream. It hadn't worked out for a few years there, mostly due to kind of family circumstances on my end, but then got the encouragement to apply, heard that there were openings, applied, and came to ADF. And I've been living the dream for the past, like I said, I think it's 8 years now, litigating constitutional appeals, mostly in the areas of religious freedom, free exercise, pro-life work, parental rights for the past 8 years now, doing appeals in state and federal appellate courts across the country, including getting to work on a few U.S. Supreme Court cases, which has been really fun.
Yeah. Well, so tell us a little more about ADF. It's not a law firm traditionally, is it? It doesn't sound like it. So give us a little bit of the history so we can put that in context.
Sure. So it's not a law firm in the sense that it's not for profit. We do call ourselves the biggest Christian law firm litigating in the free exercise, free speech, parental rights, pro-life space. I think we've got, and I'll get the number wrong, but probably 60 attorneys on staff now, somewhere in that range. So we're a lot larger than a lot of folks realize. We've been around for about 30 years now. We started off as the Alliance Defense Fund, and we were just an organization, basically a fundraising organization that was helping to fund other attorneys who were litigating cases in the free speech or religious freedom or pro-life spaces. Over time, we started hiring our own attorneys and switched from being kind of a fundraising funding outfit to being more like a law firm. We're litigating our own cases from start to finish. You know, we've got clients that come to us that have a need. We're filing the lawsuit. We're taking it up on appeal all the way to the U.S. Supreme Court if we need to. We've got an entire communications side of the house, so we're litigating cases in the Court of Public Opinion. At the same time, we're litigating cases in court, which has been a new and different experience for me, having come out of government where at the line attorney at a state AG's office, you'd better not talk to anyone in the press, right? That's not your job. But here it is a big part of our job. So that's been a fun new wrinkle. But yeah, so we are ADF stands to keep the door open for the gospel and also just to defend every person's God-given right to hear and speak the truth. So we're very intent on protecting the rights of all of us, people who agree with us, people who don't agree with us, the right to hear and speak the truth, and also just making sure that we are not just playing defense, but that we are seeking to improve our legal system for all Americans and thinking about that in terms of the long game. What are some big generational wins that'll make a difference, make this country a better place, not just for us, but for our kids and for our grandkids.
Well, you've already kind of dropped this description in there about ADF being your dream job. Tell us a little bit about why you characterize it that way.
Sure. So it really started with what I wanted to do and the type of cases that I wanted to work on and how I wanted to use a legal degree. And then since coming here, on top of that, it's turned into also just realizing, the privilege it is to get to work with the kind of people that I work with on a daily basis, whether that be colleagues, whether that be clients. And so it actually goes all the way back to when I was in high school. I had done well in school. I was an oldest child, and so I had oldest child syndrome. And so it's always about getting straight A's, doing my best at school, pleasing my parents, and all of that. And my mom and dad always told me, Christopher, we believe in you. You can do anything that you set your mind to with the gifts that God has given to you, and as long as you do it for Him and for His glory. And so, in my 16-year-old self, I thought, well, what are two really hard professions? The two that I could think of were medicine and law. And I hate math and I hate blood. Medicine kind of went out the window. So I said, well, I guess I'll pursue a career in law. And it was around that time I got a little bit more interested in politics and seeing how the legal system interacts with our culture, and how a lot of these issues that affect our day-to-day rights, our ability to speak out on issues that are important to us, are really being decided by attorneys and judges in courtrooms. And so I realized that I could use a degree as an attorney, to do work that I felt like not just was important to me personally, but work that I felt like, as a Christian, work that God, had prepared for me to do. And I could go to sleep every night thinking I've used the gifts that He's given to me today to do His work. And so I set ADF and religious freedom as kind of the goal, actually, in undergrad, as a freshman in undergrad. And it just so happened at that time, I was keeping a blog for a class that I was taking. That was back in 2006, I guess. So blogs were new. And so all the professors were like, oh, you have to keep a blog. It's this new thing. And so no one was reading my blog, just my classmates, because they had to. But I decided to post a little kind of rant about some of what I thought was wrong with our legal system and some of the cases that I thought had been decided the wrong way, and put it out into the world on this blog post. And within a few days, I logged on and had a comment from someone I'd never heard of. And she told me her name was, she told me what her name was. And she told me that she worked for Alliance Defending Freedom, and that she was recruiting law students to join the summer internship program called the Blackstone Fellowship. And that if I decided to go to law school, that I should apply for that program. And again, I had just weeks earlier discovered ADF for the first time, decided I wanted to do Blackstone. And then this message appears on a blog post that I assumed, 12 people in the world were reading, most of them my classmates. So that felt like a God moment of Him affirming, this is a path that I will bless. And so that turned into a friendship with her, and she became a mentor of mine and kind of led me at each stage of my career to where I am now.
Well, it sounds like that was the right place for you and where you were meant to be. So I'm glad to hear that story. Did you ever, when you were at the AG's office, or even at ADF, did you ever do any first level trial work, or were you always focused on appeals?
Yeah, it depends on what you count as first level trial work, I guess. So when I first came aboard at the AG's office, we actually weren't called the criminal appeals section. We were called the criminal litigation section. And the reason they called it that is because our work was split 50-50 between doing criminal appeals, like direct appeals, and then also doing post-conviction litigation, most of which was habeas. So I did a fair amount of habeas litigation in my time there. I probably handled 60 or 70 habeas cases. And so those were, you get the habeas petition filed in the state trial court. And so you would be filing trial level briefs. I had a few hearings in front of trial court judges where I think I questioned a witness 3 times or 4 times total in my time there. So I wasn't doing a lot of it, but I did get to dabble a little bit and I enjoyed it.
Okay.
Before that, I spent a year in my 3rd year of law school. I did a 3rd year prosecution clinic. And so I spent a year at least being in the courtroom, trying criminal cases, and kind of got a sense of what that feels like on a day-to-day basis.
Does the Virginia Attorney General's office do, is it mostly like habeas when they're in the trial court, or do they actually do some trial court prosecution work?
So we have the AG's office has a few sections that they come in as like special prosecutors and do some sort of trial level litigation on the criminal side. The biggest example that I can give you is they had a computer crime section that would come in and prosecute some of the child pornography cases, for example. So the cases that were really big and really intense and needed a lot of specialized expertise on those cases. So we had some individual sections, like I said, that did those types of prosecutions. For the most part, and in the section that I was in, we were doing entirely post-conviction litigation.
Well, what would you say it was that sort of directed you toward appellate appellate litigation specifically over, you didn't fall in love with being a trial lawyer like some people do. And I mean, we've talked many times on our show about how people take different paths to appellate practice. What was it about your experience that really nudged you that direction and made you think that that's what you wanted to do?
Yeah, I think two things. Part of it probably is personality, and then part of it is just the opportunity that presented itself to me. So on the personality side, I like to be very careful and thoughtful and methodical, and never put a statement out into the world unless I've verified to myself that it's 100% true. And to the best that I can, right? And so the thing that I found most unsettling about trial court work is that there are so many different things, issues that could come up in the course of a single hearing, a single bench trial, legal issues that could be thrown at you and objections and the like. And my personality is such that I have a hard time speaking confidently when I haven't had the time to dig deep into an issue and make sure that I know that issue confidently. Whereas with appeals, you really get that time to go deep. You know what the issues are going to be on the appeal. It's narrowed quite a bit. You have a pretty good sense of what questions you might get at oral argument. So you can go into those hearings with a lot more confidence. The way that kind of a shorthand that I use to describe the difference as I have experienced it myself is that at the trial court level, your knowledge base has to be basically a mile wide. There are a lot of different things and issues that can come up that you have to at least have some awareness and understanding of. But you can usually skate by with it being just a few inches deep. You don't have to know the deep down details in and out of every single possible issue that might come up. Maybe a few, but broadly, not usually as necessary. On appeal, it's almost the opposite, where you can usually get away with your knowledge base, being more like a few inches wide because you know what the single specific issues are that are coming up on appeal. But you really need to be able to go a mile deep in terms of understanding those specific issues, understanding the case law, understanding first principles that informs them and all of that. And so personality wise, I was a lot more comfortable doing that kind of work and having time to really think through my positions and my arguments and what I had to inform them. So that's on the personality side. In terms of what pushed me in that direction and gave me the opportunity to get into appeals, I honestly went through law school convinced that I would never do appeals because the friends of mine who were doing moot court and appellate type work in law school were friends who had done moot court and speech and debate and all of those things in college and in high school. And I had never done any of those things. I had a friend who had Robert's Rules of Order basically memorized, and I had never heard of that. I was like, who is Robert and what is this? I convinced myself, well, the appellate work is for those guys and
Yeah.
it's not for me. And then when I got my clerkship and started seeing appellate practice in real life, I started thinking, oh, maybe I could actually do this. And then when I took the job at the AG's office, it really hit me probably for the first time standing up to do a moot court before my first oral argument that I felt a lot more natural and comfortable doing it than I ever expected. And people have asked me, why do you think that is? Were you just born with the ability to get up and talk and have these conversations with people at a high level? I don't think that it's something that necessarily came just naturally to me. What I think that it is that probably influenced it the most. I grew up, like I said, a Christian home, very committed parents, and went to church every Sunday and Wednesday, twice on Sundays. And the church that I attended growing up was really good about getting young men opportunities to get up, to do Bible studies, to preach sermons, etc. So I'd had a lot of public speaking experience in my church and in multiple churches that I attended through college, through law school. So I was used to getting up in front of an audience, usually armed with a text from scripture, usually with some points that I wanted to make about how to best interpret that text, usually with a goal of talking about how are we going to apply this older text to a present day context, and ready to answer questions that I'm getting in the moment from attendees who maybe disagree with me or aren't sure about my points, and having to get really good at steering them back on track, making the points that I want to make, try to persuade them to interpret the text the same way that I was interpreting it. So when I got up and did an oral argument for the first time, I realized I've done all of this stuff before, but before it was scripture and now it's the statute. And before it was, lady in the back row of the back pew who had the hardest questions for me. And now it's, a judge on an appellate court. He's got tough questions for me. And so I felt a lot more comfortable than I ever would have guessed.
I never would have thought about the similarities between that background. I mean, and I should, because my upbringing was not dissimilar, but I don't know that I've ever put that together in my own mind about the similarities just in that life experience growing up as a young person in the church environment to what it means to be, what you do as an appellate lawyer day in and day out.
Right.
So that's
Yeah.
really an interesting, I don't even know if I would call it a parallel. It was more like, prefatory experience or something.
Yeah, exactly. And so what I tell people who are interested in doing appellate work or interested in becoming an attorney period, they come to me looking for, so what's your best advice? What specific internships should I get? What specific books should I read? What specific groups should I join? And one of my biggest pieces of advice is just look for opportunities to do public speaking. And that just means getting up in front of a group and sharing something in front of that group. You don't write it off because, it's not, legal, or it's not speech and debate, or whatever the case may be. Just get comfortable presenting a point, a topic in front of a group, and just do that as many times as you can. It's really great experience, even if it's completely unrelated to the law.
Well, you've done it a lot as an appellate lawyer. I know from our previous communications that you've done about 90 oral arguments, which is kind of a staggering number, especially someone. I think I can confidently say in my world, you're still considered a young lawyer.
Right. I'll take that.
And I'll leave it to Jody as to whether he will agree with that or not.
Oh, definitely. Yeah.
But at this stage of your career, it seems like that you have been given an opportunity to just do a tremendous amount of very important work on important cases and stand up and represent your clients in court. So I do want to talk a little more about your practice. We're going to, just to kind of preface some other things we're going to talk about. You've got some, aside from all those oral arguments, you've got a lot of interesting experience with some Supreme Court representation. And the other thing that I definitely want to cover, I'm going to shift the planned order of things a little bit, is your little, I don't want to say little, your side venture that you've got going that I think will be of great interest to the people who listen to our show. So
it's still little, so you can say little. That's okay. We're just getting started.
And we'll get back to that, I promise. But since we're talking really about your practice, this is kind of the setup for the second part we're going to talk about. I mean, 90 oral arguments over what period of time did that take place?
Yeah, that's over the course of about 12 years.
Wow. That is a lot. I'm just like you. I'm no mathematician, but you're doing, 7, 8, 9 a year
right.
at that rate. So that is very impressive.
Yeah. And it was, so I'll asterisk impressive. It's a lot. The reality was, it wasn't because I was impressive. It was because I was in a state AG's office that had, a certain number of attorneys and a certain number of appeals that had to be argued, and they needed bodies to do the arguments. So I tell people, newer attorneys looking for work, especially looking to break into the appellate space, don't sleep on your state AG's offices, whether it be an SG's section or like a criminal appeals section like I found. There's a lot of interesting work to be done in those offices, and there's a lot of work to go around. So the joke I tell people, that it was true from my experience, you go to a big law firm, the reward for good work is a bonus or a promotion or whatever the case may be. You go to a government office and the reward for good work tends to be more work. And I certainly experienced the more work aspect of the job. So I was doing probably more than 7 or 8 oral arguments a year at the time, definitely doing double digits most years. And the reason for that is because there was just so much work to go around. But it really does teach you a lot of things in a short amount of time. It teaches you the value of efficiency. So balancing, writing briefs. I mean, each of those cases I argued, I wrote, an appellee's brief, usually as the Commonwealth as the appellee, so writing state court of appeals, state Supreme Court briefs. And I'd have times when I would have, 3 or 4 merits appellate briefs due in a single month. And so balancing, the timing of getting those written, getting those filed. And then also on top of that, filing all those briefs, but then also having oral arguments interspersed within those briefs that I'm filing. And the oral arguments are on cases that I might have briefed, 7 or 8 briefs ago. So having to remember back, okay, what was this appeal about? What am I arguing? And so I also had to get very good at figuring out, how do I, when I'm writing the brief for an appeal, how do I prepare for the oral argument at the same time that I'm writing a brief? So when it comes time to do the oral argument, there's not a lot of extra prep, extra work to do because I just didn't have time. I think I did 2 or 3 moot courts in my time at the AG's office over like 70 something appeals. So because we just didn't have time. And so I would joke that I argued 14 cases in the Virginia Supreme Court. I would joke that my moot court for the state Supreme Court argument was the Court of Appeals argument, because that's the only time I went through the process of making the argument before the state Supreme Court argument. There were most times I was prepping for oral argument the day before the oral argument, sometimes afternoon
Wow.
before. I can remember sitting in the back of the Virginia Supreme Court courtroom in one case in particular where I had just been slammed, and I am handwriting my outline for my argument in court as someone else is arguing, because that's the best that I had time to put into it. You learn tricks in the brief writing process that will then serve you well when you're doing the oral argument. So for me, for example, I annotated my record in hard copy. I tabbed it, I highlighted it, I took notes on it so that when I walk into the courtroom, I'm walking in with an annotated record where everything's right in front of me. I digitally highlighted every case that I read in Westlaw. I had a color coding system. I had annotations in the margins. So when it came time to prep for the oral argument, I could click print, 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 print. And all those hard copies, everything is color coded already from when I wrote the brief. I would save cases for oral argument that say, I put a note that says, don't use this in the brief, but remember to prep this for oral argument in case it comes up. All that stuff would be filed away. So when it came time for the day before the argument, I'm frantically prepping. It's a much quicker process. I can get up to speed a lot more quickly because I invested so much during the brief writing process.
Sure. Wow. Trying to imagine outlining my argument sitting out in the gallery. That would be.
That was not the
stressful.
ideal. It was not the ideal. I had another time. I don't know if y'all have either of you had to argue two appeals in one day?
Yep.
I have not, thankfully.
I have. Yes.
That is a stressful experience, Todd, as I'm sure you can speak to. For me, not only was it two appeals, but they scheduled them back to back that morning. And I was the appellee in the first case, and I was the appellant in the second case. And the appellant in the first case used up all his rebuttal time. So I literally was up there for 15 minutes as the appellee, went back to my desk, got my materials, walked across the courtroom to the other side without sitting down, walked right back to the lectern and launched into my prepared opening remarks in the next appeal.
Wow.
And I was terrified I was going to start talking about the previous case during that argument, but somehow I survived. And we got wins in both of those cases. They came out on the
same panel or different panel?
Yeah, so state Supreme Court. So all the same justices. And we just pretended like what I had just been talking to them about 2 minutes earlier never happened and just launched right into the next one.
Wow.
Yeah, it's amazing when that happens. And it makes me think whether anyone inside the court is thinking about, it happens to be that this Schandevel guy is on both cases. Well, interesting. Let's put them back to back.
Right. Like, did they think they were doing me a favor there, or were they just messing with me?
They were saving you travel time.
I don't think so.
Yeah. We'll let them get back to the office earlier.
They have to park one time.
We'll be so grateful.
Well, that takes real skill to try to keep all that stuff straight. For sure. That's what a fascinating, your overall experience is just really interesting to me. Something else that we've chatted about a little is you've had quite a bit of opportunity to either assist people getting ready for U.S. Supreme Court arguments, or you've actually had the privilege of going and sitting at counsel table during argument fairly recently. And then I think the cases have been decided, if I remember correctly. So let's talk a little bit about how you got into that, because what a cool thing to get to do. So how did that first Supreme Court case find its way to your desk that you got to work on?
Yeah. So going back to what I said earlier about the benefit of working in a government office that's a little bit understaffed. That's basically how I got that. I got to sit third chair on a criminal case appeal that went up to the U.S. Supreme Court. And the reason for that, the SG section at the time was pretty small. There was the SG, and then he had a couple of deputies underneath him. So there was 3 total. That SG ended up taking a position elsewhere, which left only 2 attorneys in that section. And they got 2 cases granted in the U.S. Supreme Court at the same time, where they were the respondents in both cases. Interestingly enough, both cases originated in the same state trial court in rural Virginia, which I don't know how often the same trial judge has 2 cases in the U.S. Supreme Court in the same term. But it happened that way for that term. And so they just needed help with the research. At the time, I was still pretty green. So I was used more for research than I was used for the brief writing itself. But I got to help do the research. It was a Fourth Amendment case, so it was a fun constitutional issue. Got to help, I at least helped review the brief, gave some feedback. and then got to sit in all the moots, and then got to sit, like I said, third chair oral argument, which is probably, when you're breaking in, that's probably the best seat to sit in, because you don't have the pressure of being the one who's arguing. You also don't have the pressure of sitting right next to the person arguing. So what if they lean over mid-argument and they need something from me, and am I going to have it ready for them or not? I had, someone, a colleague in between me and the person arguing, so I had a little bit of a buffer. So I was just on the end with a notebook, just taking it in, a counsel table. I was a few feet away from some of the justices, because the bench and the tables are so close. And so it was just a really neat experience to get to see just the highest level of oral advocacy, and how engaged the justices are, and get to be a part of all of that. Now, it was a criminal case, and it was a Fourth Amendment case, and the officer probably should have gotten a warrant. He definitely would have had time to have gotten a warrant, did not get a warrant. We lost that case 8-1. So we lost pretty handily on that Fourth Amendment case, but still just a really fun, really neat experience. That was my one experience at the Supreme Court in the Virginia AG's office. When I came to ADF is at the U.S. Supreme Court. Recently, we've had 1 or 2 cases at the Supreme Court every term. This term, we actually have 4 cases at the U.S. Supreme Court. And being on the appellate team, we've got, I think, 5 or 6 attorneys on the team. And so when you have that many cases that get granted, you get a lot of opportunities to work on Supreme Court cases. So I have helped write 3 cert petitions that have been granted. I helped with the briefing on, I think, 5 merits cases after them being granted. Sat at counsel table second chair once. So I joked that I started a third chair, and then I moved my way to second chair. And I'm hoping to eventually bump off whoever's arguing and get to take over the lectern one of these days, Lord willing. And then I've been able to participate in oral argument prep with the attorneys that are arguing, sitting second or third chair. Even cases that I haven't been at counsel table, I've gotten to camp out in that war room. We set up, at our office or at a hotel for, 3, 4, 5 days ahead of the oral argument. And we just, put the attorney arguing through mood after mood after mood after mood. And we're all in there just putting our heads together, trying to make things as miserable as we can on them, so that ideally, when they get up and do the oral argument, it'll feel like a breeze, a walk in the park, compared to what we put them through during the moot process.
So are you now subjected to moots now that you're in this position? And
I have been.
Be quite a bit different from your experience at the AG's office.
Yes. So coming to ADF, we try to do 3 moots before every appellate argument. And so we do 2 internal moots and 1 external moot, where we bring in judges from outside of ADF who are more cold to the case. They're not necessarily, true believers like we are. So they might be more skeptical of our positions. And so, yes, I have been on the receiving end of a good number of moots, and it's not as fun to be on the receiving end. I like to be one of the judges and to be giving it. I tell people, raised in a Christian home, I was taught you always have to be nice, and I've done my best to be a nice person throughout all of my life. But that's why I love acting. I always want to be the bad guy, and I love mooting because it's the one time when it's helpful to be mean, and it's allowed because you're in character as a moot court judge. So I enjoy the moot court process very much.
Well, with all your oral argument experience, what do you think separates a good argument from one that really goes very well in your mind?
Yeah, I think a couple things. One is just preparation. I talked about the lack of time that I had for preparation before the argument. I was at the AG's office, but really the point of that was, I made time to do the preparation I needed to do, and I just had to do it at the same time I was writing the brief. But I was still spending a lot of time preparing. And so I'd learned that record like the back of my hand. I knew my cases, frontwards and backwards. And when you walk into an argument and you have been through every case cited in the briefs, you've read through the briefs multiple times, you have thought, responses that you've come up with to potential questions that you might get. I'm not a fan of scripting arguments. I might script my first couple of sentences, and I might script my outro, my final few sentences that I want to get out before I sit down. But I try very hard not to script, and I try very hard not to write out, not to commit to an outline too far in advance of the argument. I do tend to write my outline for the argument of the points I hope to cover. Even still, when I have more time to prepare, I write those the day before, sometimes the night before, because I'm instead spending all of my time getting as familiar as I can possibly be with the trial court record, with the cases that are issued on appeal, with the hope being that when I go to write my outline, everything that's in my head just kind of spills onto the page as I'm writing it. And then when I get to the lectern, I'm really not looking down and using the outline. It's just I've crammed so much information in my head that I can have a conversation with the justices or the judges regardless of which direction they want to take it. And I guess that was the second point that I meant to get to earlier. An argument that goes exceptionally well is one that is a conversation with the judges from start to finish. So it's not someone getting up and trying to give a speech. It's not someone getting up and trying to dodge hard questions so they can make the points that they want to make. I tell people hard questions are your friend. Hostile questions are your friend. That's the judge telling you exactly what the problem is that she has with your case and giving you an opportunity to speak to that and hopefully persuade her. So I've heard advocates come out of an oral argument, and I heard one guy bragging about, oh, did you see how I dodged all those questions? I didn't answer any of them. And I just made points out. And I thought, what a shame for you and your client. Yeah, wasted opportunity, wasting the judge's time. And you can see when the judges realize they're not going to get anything helpful out of the advocate, and they just kind of stop asking questions. And that's when you know you've missed an opportunity.
Yeah, for sure. So what do you take to the lectern with you?
So I take, let's see if I've got a copy, an example with me. I mean, I take a giant binder with me, and it's typically, we'll pretend like this is from maybe a smaller appeal, but I've got the briefs in that binder. I've got cases that I think I might be asked about in that binder. If it's a small record, I might have my record in that binder. If it's a larger record, if there's a ton of cases, I'll do a separate binder for the record, a separate binder for the cases. Those will usually stay at counsel table if it's within reach. I might bring it all up and stick those on the shelf underneath the main lectern just to have them within arm's reach if I need them. It's usually 95% of the time, it's just a security blanket. It's just, I know that it's there if I need it. And that is helpful to me. The process of building those binders is really where the learning comes for me, relearning my record and my cases. But there is the 5% of times where I'll be sitting at the appellee's table and the appellant will get a question from one of the judges about a case, and the appellant's counsel will, quote something or say something about the case, and having a binder with all the cases in it that I've annotated myself and it's color coded and I know where stuff is at. And then I can flip it open and find exactly the point that I need to respond to the point that the counsel just made. And I can stand up, and sometimes if it's a short enough point, I can read the exact quote to the judges. I found that to be a really powerful way to use the case law and shows the value of, being prepared and having the materials with you.
I do the same thing. I take a lot of printed out paper cases with me, kind of organized in the way that I need them just in case. And it comes up quite a bit, it seems.
Yep. Yeah.
Yeah. You never know. In all your preparation, you're probably not going to remember the exact language of a specific case on an issue, but having it right there with you is helpful.
Right. Or I'll remember roughly where on the page in the case that I read the point that I need is located, but I won't remember exactly what it said or how it's phrased or the exact context. And so I can quickly find it if I've got it with me. But yeah, if I were just relying on memory, it wouldn't be nearly as effective.
Well, we could spend the rest of our time talking about oral argument because it's, I think, something that all three of us think is extremely important and dare I say, even passionate about. Aside from your oral argument experience, which again is just tremendous. And one reason why I wanted to ask you on the podcast was to talk about your latest, we'll call it the side venture, I guess.
Yes.
And it's called Brief Writing Ninja.
Right.
I mentioned you being on LinkedIn earlier, and that's where I got to know you and was first exposed to you because you're always providing all these great legal writing tips. And next thing I know, I look up and you've made this announcement that you've actually formalized what you were already calling Brief Writing Ninja. And now you've kind of launched it, and you're doing things like providing training to law firms and things like that. So tell us first, how did you come up with the idea to even do this? And then tell us about what's going on with Brief Writing Ninja and where you see it going.
Yeah, thanks. I'd love to. So again, it was more being in the right place at the right time than anything that I intentionally set out to do myself. The name Brief Writing Ninja, it sounds maybe a little bit corny, but it's actually a nickname that opposing counsel gave me in an appeal that we were working on back when I was in the AG's office. So I was working on a Commonwealth's appeal where, the government, we were appealing like a suppression ruling or something, kind of limited circumstances where the government was allowed to appeal a trial court ruling in a criminal case. And I written my opening brief. and I come up with I thought a pretty clever theory for getting the lower court reversed, and got a call from opposing counsel during the time that he was writing his brief. And he called to talk about something procedural, but he said, just kind of speaking off the record here, maybe I shouldn't preface what I'm about to tell the world with him saying it was off the record. I don't think he said off the record, but he said, I'll just be honest with you. I was talking to a colleague the other day, and I told him, man, this Chris guy, he's like a brief writing ninja. Like, I don't know how to respond to some of these arguments he's making. He hasn't left me with anything that I can really say effectively. And so that was a fun moment. And it became my favorite professional compliment I've ever gotten, and, went in my file, and I kind of just tucked it away, and, it's a neat memory. And then a few years ago, when I started getting more active on LinkedIn, I looked around and thought, well, how can I engage with people? How can I add value to attorneys who are coming up behind me in the profession? And I've always been passionate about good writing, and it's a topic that I've studied a good amount. And I thought, okay, well, maybe I can put some legal writing tips out into the world and see if that's something that people benefit from and enjoy. And I noticed at the time that hashtags were really big on LinkedIn. And if you wanted to do something consistently, it was good to have a hashtag that you used for every post that you did on that topic. And so I brainstormed and tried to figure out, what unique hashtag can I come up with? And the one that kept coming back was Brief Writing Ninja, because that was that favorite professional compliment that I had gotten several years earlier. So I started sticking that hashtag on my posts, and it was corny, and my wife made fun of me for it, but it was okay. I was like, it's fun. I take my work very seriously. I try hard not to take myself too seriously. And so that was just a good natured way of putting a label on what I was doing. And like you said, things kind of took off in a way that surprised me. I posted this style guide that I put together for my own use and put out into the world, and it went viral a couple times. And before I knew it, I had law firms that were coming to me in my inbox and saying, hey, is there any chance you could come do a seminar for our firm? Like, we'll pay you for it. And I thought, sure. My wife has been telling me, if there's some way you can make money off of all this time you spend on LinkedIn, that would be really helpful. So I was like, look, honey, I might be able to. And so I did a couple of those for law firms. I started doing similar trainings in-house for ADF. I had some teams that asked me to do those trainings in-house, and got really good feedback from everyone that I had done them for. And I really enjoy teaching, and I really enjoy legal writing. And so I thought, if I'm going to have people coming to me, maybe I ought to make this a little bit more official, start an LLC, make them paying me easier for them, and taxes easier, and all of that. So it was really just kind of supply and demand, and the demand kind of came to me, and that's how it was born.
The opportunity just showed up on your doorstep after some, putting yourself out there on LinkedIn, it sounds like.
Exactly.
Well,
the
it seems like
hashtags.
ADF, and the hashtags. That's
And the
pretty
hashtags.
awesome.
And although hashtags are out of style now on LinkedIn, so I don't know that it would work quite as well as it did for me then, but they were big back then.
Well, you've kind of got your testing ground with ADF, right? You can come up with your curriculum, train the lawyers there in-house, test ideas out on them. And if, depending on your feedback, what a great sort of market test you have available to you right there. And it benefits ADF, it benefits the client. So it's a great thing to do. It's amazing that, you hear stories like this where you start something that's not really intentional, kind of like you didn't intend it to be a business opportunity really when you first started doing it, but it kind of becomes one thing you're known for. And I think it's really interesting that it's really kind of taken off on you. You mentioned your style guide, and we're going to make this available to our listeners in the show notes and for download. But I told you before we started recording, when I was setting up some templates for my practice, I put it on my desk and went through it item by item. And I agreed with most of what you said, Chris, although there's some things I want to ask you about.
Yeah, let's fight it out right here. Yeah, bring it on.
No, well, we'll go through that. So let's see. I could literally go through bullet point by bullet point and ask you questions about this. I'm not sure we're going to have time to do that. So I guess let me ask a loaded question. And this maybe help kick off the discussion on this. But what do you think in your three-page style guide, which covers a lot of ground? You cover formatting, style and tone, structure, paragraphs, quotations, citations, sentences, words, and punctuation. I mean, that's the waterfront of legal writing, right?
Right. It's everything.
What do you think is the single most important guide point in this guide that you would emphasize to someone who does what we do for a living?
Yeah, it's a great question. I've got 5 kids. It's kind of kind of like asking me to pick my favorite child. I love so many of these tips and I preach all of them. So therein lies the challenge in singling out just one. I think the one that I would highlight in terms of, easiest to implement and also most bang for your buck in terms of improving your legal writing is my tip about starting more sentences with sentence starting conjunctions. And so those three being specifically and, but, and so.
Mm-hmm.
We attorneys get convinced that legal writing is just a different animal from most writing. But the reality is good writing, period. One thing that I've noticed in a lot of legal writing is those transition words between sentences. We tend to make those transition words very clunky. So we love words like accordingly and nonetheless. And even however it's not a long word, but it's a 3-syllable word. So it's clunky. I think the vast majority of legal writing could be improved if attorneys would basically triple the number of sentence starting conjunctions that they're using in their brief. So instead of saying moreover, just say and. Instead of saying, instead of saying, nevertheless, just say even still. Instead of saying, accordingly and however, just say but. Start the sentence with but. It makes for punchier writing. It also honestly makes for clearer writing. Even if you're slowing down the reader a millisecond, you can avoid that by just saying and, or just saying so, or just saying but, words that are immediately clear what they mean. And so that's my biggest one. Most attorneys don't do it, I think, because a lot of us were taught in grade school you're not allowed to start a sentence with a sentence starting conjunction. I still get English teachers on my LinkedIn comments who fight with me and say, I'm violating some basic rule of grammar. And I have to tell them, no, that's not a rule. That's a myth.
Yeah.
Read any good fiction. And I think it's because when you're a kid and you're starting to learn how to write for the first time, the temptation is to, if you're writing a story, and then my mom did this, and then my brother did this, and then we went to the store, and then every sentence starts with an and. And so the teachers have to be like, stop starting every sentence with and. And so we get in our head that we can't start a sentence with an and or a but or a so. But the reality is that's just not a real rule. And the best writers for centuries have done it.
I think I'm seeing it more, than I used to. 20, 25 years ago, it went against nature for me to do that, to use, sentence starting conjunctions. But now I've grown to where I really like it. And for a lot of the reasons you describe, it's much plainer and easier to understand. You're not injecting unnecessary syllables or interrupting the flow of your sentences. It just reads better. So I'm a fan. I've been converted. It didn't take very much for me to get converted. So you talk about formatting. Maybe we'll hit a couple of formatting points here. And the one I think that struck me the most in your guide, I agree with just almost everything you say in here. And a lot of it, you wisely direct people to learn styles in let's just say Microsoft Word, because that's what most of us use, right?
Right. Yep.
It's amazing. I still see law firms who don't know what that even is. And when you are in my role and in Jody's role, a lot of times we're working with lawyers from other firms who send us stuff on their original template. And
the formatting,
my
merging the
my
formatting
ADD,
and
OCD brain just kicks in, and I just can't even read it. It's just awful.
Right. Yeah.
You should almost never use a tab when you're writing a legal document, right? Your styles should be pre-formatted. And you give a lot of good tips in here on how to style things. As I said, I adopted a lot of this when I was creating my basic brief template. The one thing I want to quiz you on a little bit. First of all, I agree with using Century Schoolbook. That is my font of choice.
Good.
Isn't that still what the U.S. Supremes use?
It's still what the Supreme Court uses, right? So if it's good enough for the U.S. Supreme Court, it's good enough for me. Jody, are we 3 for 3? Are you on board with Century Schoolbook?
We use a variety, and it depends. I have used it before. That's one of the ones. There's a bunch of different ones that we use.
But the thing that I almost said triggered me, it really didn't. But the thing that caught my attention was your idea of aligning left.
Yes.
And you probably get some pushback on that, don't you?
Absolutely. No, I was the one giving the pushback when I first had to make this switch.
Yeah.
So I can relate to the pushback.
So I think, we see a lot of full justification in legal writing and documents. And that visually, that's kind of appealing, right? Because you're sort of boxed into a specific zone in the document. I looked at that when I was setting up my styles, and I was like, Yeah, I just don't know that I can do that because what you get is that jagged right edge, right?
Yep. Right.
But I know the flip side, and you'd probably say this is the next thing that we talk about, but the flip side is your spacing is uniform. And so the words all look the same on the page. It's just a matter of that jagged right edge. So you used to be the one giving the pushback, you said. What
Yes.
made you change your mind?
Mostly my boss told me that I had to change to a different formatting, and that made me change my mind, right? But in terms of what persuaded me, I have been persuaded. I'm a full convert to left aligned now, and it's a couple things. My initial pushback was, fully justified on both sides. It just looks clean, like you said. You've got a
Mhm.
clean edge on the left, you've got the clean edge on the right. Just looking at it on the page, it looks nice. The other side of that coin, though, like you mentioned, is once you get to actually reading the sentences themselves, you see that in order to get those clean lines on the left and the right, some of the lines get stretched out quite a bit, and you've got the large gaps between words in some
Mhm.
lines. And then the next line, you won't have those gaps because that line isn't needing to be stretched out as much. And the result can be what's called a river of white space, where if you get
Mm.
those spaces to line up down the page, your eyes, as you're reading through the text, get distracted by just the river of white space kind of falling down the page. And it's something I did notice back at the AG's office quite a bit, where everything that we wrote and read was pretty much fully justified. So you avoid the spacing issues. The other thing that persuaded me, though, with left aligned is that you want a little bit of a jagged right edge because it makes the brief easier to read. And the reason for that is because it's easier for the reader's eyes to keep track of where they're at and moving from one
Mm.
line to the next. If every line looks the same at the edge, it's easy for the eyes to lose which line was I on. But if you've got a marker of, okay, it was this line that was this long, you can find the next line a little bit easier. It's not a huge difference, I don't think, but every little bit I think counts when it comes to making briefs more readable. I will say that my bigger point that I'm really intent on, whether you fully justify or left align, I'm less of a stickler on that because I can see that the position for fully justified. Regardless of which you're doing, you need to be using optional hyphens. And the reason that they're optional, that doesn't mean you turn on hyphenation and you let the word processor choose when it's going to hyphenate your words at the end of the page, because then you get all sorts of crazy, funky hyphens that just end up distracting you more than if you hadn't been using it. But an optional hyphen is when you have a huge gap because you're using fully justified, or you have a overly jagged right edge because you've got just a really long word that's falling down onto the next line, and you do get that ugly look that you're mentioning, Todd. You insert an optional hyphen between syllables to break up that word, and you bump part of it back up onto the prior line and allow part of it to spill over onto the next line. And one, it cleans up the gaps if you're fully justified, or it cleans up the gaps on the right side if you're using left align. And then two, the beautiful thing about an optional hyphen, since you're not inserting a hard hyphen that's going to stay no matter what. So an optional hyphen, I think, is Control Alt hyphen, if I'm remembering my shortcuts correctly. The reason it's called optional is because when it's no longer needed, it disappears. So if you're adding words before that word that was breaking across lines, and then it ends up just naturally getting entirely bumped to the next line, the hyphen just drops out by itself. So you don't run the risk of filing a brief with an awkward hyphen in the middle of a word where you didn't need it. It comes and goes as needed.
Oh, that's cool.
Well, I was going to ask you if my solution of turning on hyphenation was acceptable. And
Yeah, my
so,
concern is that you end up, in order to avoid the distracting big edges or the distracting gaps between words, you end up hyphenating almost every word that comes at the end of a line. And then there's just so many hyphens that you've got like worse distraction than what you
okay.
started with.
Well, you've made me. You're going to make me reconsider and reevaluate my design.
Good.
The optional hyphen thing. I remember I saw it in here. It's mentioned in the guide,
Uh-huh.
and
Yep.
that seemed like maybe a little farther than I was initially inclined to go. But you've persuaded me that I need to at least give it a fresh look and see, because I like the idea of the optional hyphen that takes care of it when it's just too much of a space, but it drops off, as you said, when it's not needed.
Right.
I wanted to ask
Okay,
you
I
about.
wish we had time to go through all of these, but we don't.
Well, I do want to ask you about one, just because it's one that I don't hear people talk about, and I'm just curious if you'll explain it a little more. True double spacing.
Yeah. So true double spacing, you might think that if you turn on the double space setting in Microsoft Word, it would double space your briefs for you. You'd be wrong. It adds an extra 15% of white space between lines. So it's not exactly double, it's double plus 15%. And that additional white space, the thinking is the more space you add between lines, the looser it gets. Again, it makes it harder on the reader to track from one line to the next. So a guy named Matthew Butterick, who wrote Typography for Lawyers, y'all probably both know who he is. He advocates for using true double spacing or exact double spacing. And the way that you turn it on is in Microsoft Word. Instead of clicking the default double space option in your paragraph settings, you change it to exactly, and then whatever 2 times the size of the font that you're using. 14-point font, it's exactly 28 spacing. You get lines that are just a little bit tighter together, which just, again, makes it more readable moving from one line to the next. I do throw in a word of caution that if you're in a jurisdiction that operates based on a page limit instead of a word count, you can create the impression that you're trying to cheat the page limit if the judge or the law or the clerk's office doesn't know what you're doing and why you're doing it. So out of an abundance of caution, I tend to call clerk's offices if they're using a page count instead of a word limit. And I'll just ask, like, hey, this is the way that I space my briefs. Is there any unwritten rule against that I should know about? I'll even, if I'm the appellant in an appeal, I'll reach out to opposing counsel beforehand and just say, hey, this is how I plan to space my briefs. You're welcome to space them the same way. That way we're all on equal footing. No one thinks I'm trying to get an advantage by squeezing in, more lines on the page. And so far, I've never run into a problem. And I do think it makes the briefs more readable.
Yeah, I'm glad you asked that, Jody, because I really didn't understand that too well when I looked at it the first time. And now it's you've given a good explanation for it, Chris. I thought of interest, the last bullet point in that formatting section, you talk about preventing runts or short lines. And I am completely on board with that, because there's nothing I hate worse than one word carrying over to the next line of a paragraph.
Yep.
And you've got all that white space. And I will revise the paragraph until that runt is gone, because I just can't stand the look of it.
Same.
But I'm glad that you've given a description for what I otherwise didn't have a description for, runts or short lines.
And I had to Google it to get that description. I didn't realize that someone called it a runt, but that's what they're called. And not only the aesthetics of it, and I do think aesthetics matter, because it's all about building credibility with the court. And so if you show that you are intentional about even the smallest things, that increases the likelihood that a judge is going to think, okay, this is someone who's intentional about the big things. This is someone that care about the details. So I'm going to be able to trust them on the bigger stuff as well. But it's not just aesthetics. It's also, there's a psychological effect. I think if you see a giant paragraph on a page and at the very bottom of that paragraph, there's a single word that's spilled down to the next line, at least to me, that paragraph looks like it's about to tip over and come crashing down, right? It's like a giant Jenga block with one lowly block at the bottom, all the way in the far left. And so it just looks unsettled. And so if you can bump that word back up onto the previous line and have a very nice, smooth, solid landing for that paragraph, it makes the writing and the argument feel a lot more grounded and concrete and solid as well.
Yeah, you mentioned in here also the orphan and widow control. I mean, that's an internal setting in Word that definitely needs to be turned on. Keeping lines together. Those are all great points that we won't get into the details of, because I think it's sort of, it goes hand in hand with setting up your styles in Word, but just having those settings on will go a long way.
Yeah. Can I tell you though, on the orphan widow control, I don't know how much if you've noticed it, I'm a bit of an extremist on orphan widow control. So for me, very basic formatting is, you don't want a single line to bump over onto the next paragraph, or you don't want, a single line onto the next page. You don't want a single line from the start of a paragraph to be the last line on the page. I mean, that just looks gross. And so orphan widow control prevents that. At least you have 2 lines that are stranded at the top or the bottom of a page, and instead of just one. To me, that still looks gross. And when you're reading a brief, whether it's hard copy or digitally, you have to keep that thought in your head as the reader, as you flip from one page to the next, as you scroll past the white space on your iPad, getting from one page to the next. And so my ideal formatting is kind of like orphan widow control on steroids, which is ideally you should end the complete paragraph at the bottom of each page and start a brand new paragraph at the top of the page. So you don't have a paragraph splitting in half over 2 pages. The nice thing about that, it's about making the brief as easy to digest on the reader as possible, because the reader can read a page and then answer a text message or get up and make a sandwich or do whatever the judge or the law clerk might need to do as we're constantly getting interrupted. And then pick the next page up and find exactly where they were, not have to keep that thought in their heads, in between that from one page to the next. And so it's something that I strive to do in every, I will file a 50 or 60 page brief And if you go through and count the page breaks that are not clean, like I described, I've managed to get it down sometimes to 3 or 4 places where I have a paragraph spilling over from one page to the next. But
Wow.
otherwise, clean breaks. It takes a lot of extra effort, but again, it's about making things as easy to read on the reader as possible.
No, I hadn't quite heard that one expressed that way before. So that's super interesting. So style and tone, the main thing I wanted to ask you about here, well, first of all, you mentioned Matthew Butterick. He was an early podcast guest of ours. So
Excellent.
we're Butterick fans also. But the next thing that's flagged for me under style and tone is you talk about brief catch. And I'm a Guberman fan, Ross Guberman fan. And I actually want to, if he ever hears this, I want to plant the seed for him to come on the show to talk about what they're doing at Brief Catch, because it's really pretty great right now.
Yep.
You talk about when the draft is complete to run Brief Catch on it. It's, for anybody who doesn't know, it's software that basically they're going through some changes right now with the word rake. They acquired word rake. So I'm still trying to get used to how Brief Catch in Brief Catch Plus works, but I've found it's really a great service and certainly well worth the money that you pay for it, because it will check your citations, your abbreviations in your citations. It will check it's not like Grammarly exactly, but it will make suggestions, and it's based on Ross's. I heard an interview with him recently where he basically said they hard coded in all of these examples of exemplary legal writing, and they've managed to basically turn that into through the use of AI. It will call out the things that it thinks can be improved, and will give you examples of how to say it better, and cite to, say, Scalia or one of the other U.S. Supreme Court justices, which tends to be sort of his bias for what good legal writing is. So totally on board with Brief Catch. Did you have anything to add to that?
Yeah, no, I'm a huge fan too. It's basically like having Ross Guberman as your editor, but he just lives in Microsoft Word. And so you write the brief, you click the button, and then he gives you all of his edits, with examples for, why they're edits worth making. You just go through, you click through. I accept most of them, but then there may be occasional one where you, usually I wouldn't use the word clearly in a brief, but if you're operating under a clearly erroneous standard, you have to say that word. Sometimes you have to reject a word for those sorts of reasons. But for the most part, it's fantastic. The advice, the editing tips are fantastic, and always takes what I feel like is a pretty well written brief and just takes it up a notch.
Yeah, I think we all three agree on that, because I do love having it too. It's always sort of my final check before I get it ready to file.
Well, that's it. What I'm going to do now is I'm going to send Ross a clip of this conversation.
Yeah, I'd love to have him back.
Yeah, he's fantastic. He's doing really, really great, interesting work with AI now, and his reality checker, where it'll check to make sure you haven't had those fake cases creep into the briefs that you're filing. Attorneys keep getting in trouble for, and not just that. I think the fake cases that have been cited in briefs obviously are horrible, but to me, it's less a sign of the risk of AI and more just a sign of the risk of not careful lawyering.
Yep.
And that's something that's been a problem, long before AI came around. And so the nice thing about Ross's reality check is that not only does it check to make sure the cases aren't fake, it also makes sure to check that the propositions that you're citing cases for are accurate and come from the cases themselves. And that's often not an AI problem. It's just a problem of attorneys stretching cases and holdings and rulings to fit and say what they want them to say. And so his software does the job that a law clerk or a judge is going to be doing when they look behind your writing to make sure that you're being careful and you're being accurate with the cases you're citing. So it just adds a ton of value.
We would need at least another hour to go through all the things that I could talk about in the guide. There's really two other things I wanted to bring up, just because I think these are useful things to talk about. One is directly tied to what you were just talking about AI. It seems like the N dash, or the M dash rather, is kind of become stigmatized by AI. I'm not going to give it up. I don't care what anybody says. But do you have any feelings on that? I know you're generally an advocate of proper use of the N dash. Well, let's make sure I'm talking about the right thing, though, because
you've got it. The M dash is the longer one that that AI has been using, and the N dash is the shorter one that you use in like page ranges.
Right. No, and I may say the wrong one, but I know in my head what I mean.
Yeah, just remember an M the letter M is a little bit wider than the letter N.
Yeah.
So the
Right.
M dash is the wider of the two. Yeah, no, I'm a huge advocate of using M dashes in briefs, both to set off parentheticals, especially when you have a long sentence and you want to make it clearer and less complicated. If you have more than 2 commas in a sentence, it's going to start to get unwieldy and complicated because you lose track of, okay, which comma goes with which other comma and where are the clauses here. So anytime I have commas already in a sentence, I start thinking about, can I change some of these extra commas into M dashes so it's clear, where the clauses are, and then also using them at the end of a sentence to emphasize a point. Basically, it slows the reader down, and then you kind of hit them with a boom at the end of that sentence after that M dash. So I use them to add emphasis as well. And I know that there are people out there who say, well, now that AI uses M dashes so much, we should stop using M dashes because we don't want people to think that we're writing like AI writes. The reality is AI is just using them because they're good tools for good writing. And so I think that mindset is basically one that says, well, if AI can write well, I don't want to be confused with AI, so I'm going to start writing horribly, so that no one
Make my
confuses
writing
me with
worse
AI.
to prove I'm not AI.
Exactly. So cutting off your nose to spite your face, basically. So yeah, the machines will have to pry my M dashes from my cold dead hands is basically my position on that.
Yep.
I think we're in agreement on that for sure. All right, but real quickly, since we talked about N dashes, that's one thing I have not been able to get on board with is swapping out hyphens for page ranges for N dashes. I just think it looks weird. It looks like you're trying too hard, maybe. I don't know. I've seen it both ways. I've seen people who agree that maybe it should be an N dash, but just say you can kind of have the viewpoint that I do where it's like, I just can't go there.
Yeah. Yeah. I think
Change my mind.
Yeah. So I don't know if I'll change your mind. I will say, in your defense, I think the Blue Book allows either. So there's not a one right or wrong. I'll also say that using hyphens between ranges treats the two numbers as one word. So you save on your word count if you're hyphenating instead of using indashes. So that's a helpful tip for people who are up against the word count often. For me, the biggest reason to use the N dash is because sometimes you have to use a hyphen in like a record number or elsewhere in a citation. And if you're using hyphens in like a record number and then also using a hyphen in the page range, it can sometimes be a little bit confusing looking at the citation to figure out, okay, where are my page ranges in here and what's just a different part of the citation. And so there are times when it adds some clarity to know that you're always going to use an N dash between the page ranges because it's easier to tell what in the citation is a page range. Now that's a very small, minuscule point that doesn't come up a whole lot, but it's what slightly tips me over the edge to use the N dash over the hyphen.
All right. I think the last substantive question, because we're out of time, and we're so grateful that you spent the time with us
Happy
today.
to do it. We can't end the podcast on the difference between hyphens and N dashes, can we?
Oh, no, I have one that maybe will spark a little more discussion, and then Jody's going to ask you for your tip or war story. But under the quotations and citations part of your guide, I've noticed you do talk about minimizing the use of brackets and ellipsis and internal quotations and those sorts of things, footnote references, all the things that we were taught to include to be true to the actual site, right? And now the brilliant law students at Harvard Law School have decided that we can use the phrase citation modified.
Yes.
And there's a little laundry list of things that allows us to do, if I understand that rule correctly. I assume like the last brief I wrote, I actually went back and looked, okay, do I have any ellipsis in here? And I did. And I thought about it and I was like, I don't need that. I can use citation modified and fix it. And it will look, talking about pleasant visual experience with your briefs, it will look better to the reader.
Right.
And so I employed that. You mentioned citation modified specifically in the guide. I just wanted to throw it out there mostly for our listeners because I know you know what it is.
Right.
And I know Jody knows what it is. And I mean, we all kind of went through the cleaned up phase before the Blue Book kind of co-opted that concept and put another name on it. Anything you'd like for our listeners and viewers to know about citation modified besides what I just said?
It's a really useful parenthetical. And even though the Blue Book has endorsed it and they call it citation modified, it was, the originator was an attorney named Jack Metzler. who said, I don't want to write quotation marks omitted, emphasis omitted, reference, footnote, call number omitted, and have all these giant parentheticals behind a citation. But when all I'm doing is, if I'm quoting something from a case and the case that I'm quoting was itself quoting a different case, I don't need the reader to know the case under the case that I'm quoting. I just need the reader to know what the court that I'm quoting was trying to say. So if that court had to add some ellipses or add some brackets in order to say what the court that I'm quoting wanted to say, I can strip out those brackets and those ellipses and still be true to the source that I'm quoting. So that's what it's useful for. And instead of all the parentheticals, you just get a single parenthetical that represents all of that, which is citation modified. What you have to be careful of is, if you're inserting your own ellipses, if you're deleting a word or two, or if you're changing a word from capital to lowercase, if you're making changes to the source that you're quoting, and those are your changes, those are your deletions, you decided to take some words out, then you do have to use the ellipses. Then you do have to use the brackets, because you do need the reader to see these are changes that I made to the substance of the quote that I'm quoting. But if you're just stripping out brackets and ellipses that source put in there and modifying the source that they were quoting, that's when those are just additional, clunky bells and whistles that really aren't serving any purpose for the reader.
Chris, we are so grateful, and we kept you right up until the end when you have to go, but thank you so much for all these tips and everything. And we'll post the style guide and make it available to people, because it is a useful kind of 3-page quick reference way to really, max out your legal writing with pretty easy controls. So thanks for joining.
Yeah, thanks so much for having me on. I had a lot of good time. My wife is a long-suffering attorney's wife, and she humors me when I try to talk to her about the law and legal writing and oral argument, all these things that I'm passionate about. But it's not often that I get to spend a good hour of my time just telling appellate war stories and talking about the finer details of legal writing with people who care about these things as much as I do. So I've enjoyed the time together, and I really appreciate you guys having me on.
You bet. Thanks for being with us.